Hey, good morning, everybody. Welcome back to Law and Legitimacy. It is Thursday. Well, it took me 3 days to get the day right this week, but I finally did. Hey, Mike, how are you today?
I'm doing
What's up?
well. I'm
What's up?
frenetic. I'm frenetic today. Man, I had an incident with some pre-workout this morning. I switched brands, and the potency of the pre-workout I took this morning was at least an order of magnitude more than what I'm used to. So I was in a frenzy at 5 a.m. this morning.
You're talking about like an energy drink or something?
Yes, so it's sort of a powder that you mix into water or whatever, and then you use is sort of a to get you amped up and like really engage in the workout. So, that was interesting this morning. I was doing like backflips and cartwheels and whatnot. I was just not in a great place.
I think that's called hypomania. You may want to speak to a psychiatrist about that. Me, I was sleeping. I'm still recovering from the last 5 years. My wife said to me last night, "You think you're sleeping too much?" I'm thinking I could sleep for another year. I mean, between the Jones trial, the Proud Boys, Fotis Dulos and his suicide, the suspension from Judge Bellis, and the continuing fight on that, there'd be a little bit of stress in my life right
I
now.
can imagine so. I can
So
imagine.
anyhow, let's get to it this morning. Lots to talk about. And I guess the best place to start is with the jury instructions in the Trump case. There's going to be a lot of misunderstanding about that in the news.
Too soon, Jeff.
What's that?
I told Jeff too soon. Don't go Nick on us. Anyway, listen.
What is? Yeah, tell me what is going on with Nick. I put a call in. Somebody, Eric Huntley, had urged me to reach out to him, and I put a call into Nick. I see that he's been arrested, and apparently this is a source of some internet comment. So it's Nick Rekieta, and what's going on?
So I'm even reluctant to comment very far on this.
Yeah, no, we don't have to go far.
Well, look, you and I are outsiders, right? So there's an entire law tube community. There's an undercurrent of relationships between these people. It's still unclear to me who knows whom through whom, right? But what we know is that Nick Rekieta is extraordinarily popular law tuber, as it were, very productive. Live streams many of the most high profile trials. And there was a search warrant executed at his home. He and two co-defendants were arrested on charges of drug possession, all sorts of other stuff. And it has created a massive fissure in the LawTube community among those that know and ostensibly love and care for Nick. So that's why I said I'm a little bit reluctant to even comment on it.
Our heart goes out to him.
You and I are just, we're new to the party, so we didn't come here to piss anybody off. At least not without knowing exactly when we're doing it. You know what I mean?
Yeah, I hear you. So customer states PNW, potentially criminal, would be a good guest for Norm to hear about the Nick. I don't know who potentially criminal is. Hook us up. We'll have him on. We don't have guests on that often, and we probably should. That's a sign that we're both pretty busy working on our own legal careers. And
hey, we got super chats back. So for all of you that were saying, hey, do the super chats, I was able to get into the YouTube app on my phone last night. I was just playing around. I discovered that the buttons had been turned off somehow, and they're back on. So somebody test it.
All right. Well, look, I want to give some credit to a blogger named, or a social media person, David Pivtorek, Pivtorak. He got ahead of the story of what I will call the specific unanimity issue in the Donald Trump jury instructions. There will be a lot of misunderstanding about that. And I want to break it down in neutral terms that apply in every legal case, not just Donald Trump's case. In a criminal case, the state bears the burden of proof.
This is the thread that I think I sent to you.
It is. Yep.
So he says, I do want to introduce it this way because I thought it was helpful. Now he did, just for full disclosure, he did, I think 8 hours after he originally did this thread, he went back and said that, okay, we now actually have the jury instructions and, paraphrasing, but these are a doozy. So I'm not sure how much this holds up in terms of his substantive, I guess, acquiescence to the instructions themselves. But I thought that this was a really great sort of threshold introductory way to get at the nuance of these instructions, Norm. So he says, seeing a lot of confusion, obfuscation, blah, blah, blah. First, let me preface by saying I believe this is politically motivated, fair. Uh, he doesn't, he thinks that he's likely going to be convicted, but it'll be reversed based on procedural issues. And he says, let me explain. The crime Trump is charged with is felony falsification of business records. What the prosecutors have to prove is that he unlawfully falsified records with the intent to commit another crime. So the jury has to unanimously agree that he unlawfully falsified records, but they don't have to unanimously agree on the underlying crime, like campaign finance or tax fraud. This is similar to a crime like burglary, where a jury can convict if they agree you unlawfully entered someone's house, but don't have to agree on what crime you intended to commit inside. State Supreme Court decisions since Richardson and Shade have held this jury instruction to be constitutional. So the point here is, yes, the jury instruction here is probably the correct one. There's a lot to be furious at with respect to this trial, but it's important to direct that anger at the right people and issues because remember, credibility is everything.
So the issue here is what's called specific unanimity, and it comes up in criminal cases all the time. The state has the burden of proving each and every element of the offense charged, and each and every element. And an element, think of elements as the recipe in a cookbook. And you might have to prove in murder. Well, I'm preoccupied with murder because I'm in the middle of a murder trial. You have to prove the intent to kill, and then that the person killed, and that your client is the killer. The state has to prove each and every one of those elements beyond a reasonable doubt. If an element of the crime, as in the Trump case, is falsifying a record to cover up evidence of another crime, what the state has to prove by unanimity is the falsification of the record. Specific unanimity adherents, and I'm one of them, say that the state should also be required to prove with unanimity the underlying crime for which the falsification took place. And this is a nuanced issue. I keep hearing television commenters pretend it's all that complicated. It really isn't.
And Norm, I think I recall early on in our streaming days, not even the streaming days, maybe just when we were doing the long form interviews, you've spoken about this issue before. This and there's like, so I don't want to call them pet issues of yours because I don't want it to sound condescending or frivolous, but one of them is, last best offer under seal. You've mentioned that a lot over the last several years, and then specific unanimity you've mentioned before, but I feel like now that this is coming to bear, I'm recalling that you've talked about this and
Yeah.
where you land on it before in particular.
Well, so I mean, it seems to me that if the state has the burden of proof and the defendant need prove nothing, and the state has to prove its charges to the satisfaction of a unanimous verdict with respect to the elements, it seems to me to be dishonest to say that if one of the elements is you falsified a record to cover up evidence of another crime, it seems disingenuous to say that jurors don't have to agree on what that other crime is. And so in the Mershon case, jurors could answer the following question unanimously: did Trump falsify a record at count one? Yes. Then another count: did he falsify it with the intent to commit another crime? Answer: they could say yes. However, in that second instance, the jury may not have unanimously agreed on what that other crime was. So from a criminal defense perspective, you look at this and you say, wait, the state's burden of proof is being diluted, diluted. Not diluted, but diluted. It's being watered down to the benefit of the state. And so the state Supreme Courts and the United States Supreme Courts have struggled with the issue of specific unanimity, and they have held that specific unanimity is required with respect to the elements of a crime, but not necessarily with respect to the facts on which those elements are based, or that they're with respect to defenses. So I have been hot to trot on this issue in up to and including the Connecticut Supreme Court with respect to the state's disproof of self-defense. And we got the state Supreme Court to agree that the charge was a hopeless mangle in a case. And now the courts have, now the state has, the judicial branch has reformed the self-defense charge, but it really didn't address the issue of specific unanimity. I think what's going to happen in the Trump case is a lot of people are going to say, wait a minute, the court diluted the burden of proof here to assure a conviction of Trump. I don't think that's right. I think that it simply applied standard law that works to Trump's disadvantage in this case, and specific unanimity should be required, not just as to the element, but as to the predicate of the predicate facts on which the elements are based. And now the problem with this is we take general verdicts in criminal cases, and we don't usually do what we do in civil cases and send specific jury interrogatories or questions to the jury, such that the court can read the questions and determine whether the verdict is consistent. And so it's a problem. It works to Trump's detriment. I think the law is wrong. I think that if Trump is convicted and he takes this issue up on appeal, he will lose it, however, because the law is pretty clear. It's inconsistent with the general instruction on the burden of proof. But the law, as Dickens once noted, is often an ass, and it's never more of an ass than it is with respect to the question of specific unanimity. If a jury has to agree unanimously that Trump falsified a business record, and it has to agree that he falsified it for purposes of committing some other crime, it seems to me a matter of simple logic that that jury should be required to be unanimous on what that other crime is. To suggest that they can split their verdict on that four can decide it was this crime, four can decide it was the other, and four can say, well, we don't know, it was just bad, is basically to make a game of Russian roulette out of the process of taking a verdict.
Just so we're clear here, though, they're in order to get to the specific underlying, I guess, alleged conduct that enhances to a felony. But there's the falsification of business records, but that's the first threshold, no? And I want to make sure because some of our viewers
Yes,
are asking.
yes,
But there
yes.
does need to be a unanimous verdict on that to get to the second analysis, or no? Is it
There does. So my understanding of this case, and again, I'm like every other commentator. I'm not at most other commentators. I'm not at the trial. I'm reading about it. It's not televised. I have a limited amount of time, as do all of you. But my understanding is that Trump has been charged with falsification of business records, and the charge is a simple one. He listed the hush money to Stormy Daniels as a retainer to Michael Cohen, and that it wasn't. It was repayment of a payment to Stormy. So if that is in fact falsification of a business record, that is the first question the jury has to decide. My understanding is that is a misdemeanor offense. In order to transform that into a felony, that is a crime with more serious consequences. I mean, I'll distinguish a felony from a misdemeanor for you in a moment. In order to transform it into a felony, those records had to be falsified for the purpose of covering up another crime. And it's that other crime, the identity of that other crime, that hasn't been really addressed by the prosecution, is according to what I've read. But it's that issue on which the jury doesn't have to be unanimous, and that's the troubling question.
Yeah, I mean, I'm going through these jury instructions, and it's not, I'll start with on page 23 or 24 of the document here. I'll pull it back up. It says the charged crimes. I will now instruct you on the law applicable to the charged offenses. That offense is falsifying business records in the first degree, 34 counts. And then the very next stuff goes to accessorial liability. So I'm just imagining, Norm, like this isn't exactly in contrast to the name, it's not an accessible topic for a jury to encounter for the first time in terms of understand in a case like this, the concept of I guess indirect liability, or sort of mere presence at the scene of a crime, or something other than um, direct liability, actual and proximate cause. In other words, as a method or a theory whereby a criminal defendant can be held guilty of that crime, and it's not short, right? And so I think you were saying that I said these jury instructions are 55 pages long, and what did you respond to that?
That's nothing. I mean, so one game that lawyers, at least I like to play in a courtroom, is when a judge is about ready to read a jury charge, you ask everybody, all the participants, the lawyers, to estimate how long it'll take the judge to read the charge. And everybody writes a number down. And then, the person who's closest wins the honorific bet. I once had a case where it took a judge 4 hours and 9 minutes to read the charge. And it was brutal. And the charge was over 100 pages long. It was a federal case. It took the jury less time to reach a verdict than it did for the judge to read the charge. But jury instructions are at the very heart of a criminal case, and it's one of the issues over which appeals are frequently taken. It is the court's responsibility to instruct the jury on the law. The parties have the right to tender and the responsibility to tender, that is, to offer jury instructions for the judge to consider. There's usually what's called a charge conference where the parties argue what the appropriate law to be charged is, and then the judge decides what it will be, and he reads the charge to the jury. In many jurisdictions, they give a written copy of the charge to the jury as well. And so, jury instructions are pivotal. The issue of specific unanimity, however, which is the issue we started with here, is well decided law in New York and in many other jurisdictions. And so it's not going to prove an appellate issue, even though it should.
I put this here on the screen: intent to commit or conceal another crime, which is really kind of what makes me queasy just reading it based on the context of the case. Uh,
Mhm.
in the second paragraph, under our law, although the people, that is the state, must prove an intent to commit another crime to aid or conceal the commission thereof, they need not prove that the other crime was in fact committed, aided, or concealed. And I think that's really sort of like where this stuff starts to really come untethered, right? Because the prosecution has lofted these three other theories of potential potential crimes, but that's been the entire question since the very beginning of this case, is that there's an enhancement aspect to this that's driven principally by those sub theories, right? Um, but falsification of business records, he is reasonably certain misdemeanor, as you just described. But then where this stuff really goes off the rails for me is thinking that um, anything less than a unanimous decision on any of these sub theories could be an administration of justice, criminal justice in this case. It just really kind of makes me crazy thinking about it.
Welcome to criminal defense land. I'm looking at some of the comments. Blue Raptor. You should really watch another show, given your persistent dissatisfaction with what I've
He
said.
loves
But
us, man. He
I
loves
doubt
us.
for a moment that Alan Dershowitz said anything different than what I said about specific unanimity. That's black letter law, and any lawyer who's competent knows it. With respect to the intent to commit or conceal another crime, I think what troubles you here, Mike, isn't specific unanimity, but it's the language that says, under our law, although the people must prove an intent to commit another crime or aid to conceal the commission thereof, they need not prove the other crime was in fact committed. In other words, all you had to do was the desire to commit the crime. And people are often confused by the law of attempt. Under our law, if you attempt to commit another crime, that is, acting under circumstances that you believe would make it possible to commit a crime, you take a substantial step toward committing it and fail to commit the crime, you're just as guilty as if you'd succeeded. And so,
Here's the money shot. Although you must conclude unanimously that the defendant conspired to promote or prevent the election of any person to a public office by unlawful means, you need not be unanimous as to what those unlawful means were.
yeah, no, I hear you. It's tough. Specific unanimity is a difficult problem in the law, and every criminal defense lawyer knows it. Hey, let's pivot to Alito Gate.
I love
So
this.
Samuel Alito, a justice of the Supreme Court, was asked to recuse himself from any case involving January 6th, and the basis of the recusal apparently are flags that were flown at his home. And Alito responded to a letter written to him by um, uh,
Senators
Robert,
Durbin and Whitehouse.
and that letter apparently was written earlier this month. He responded yesterday by noting, or I guess it was yesterday. He responded yesterday by noting that although they wrote their letter to the Chief Justice, each individual justice decides whether to recuse himself, and the standard for recusal is whether any reasonable person would have grounds to doubt whether the judge could be fair and impartial on an issue before him. And apparently, the senators took issue with two flags flown at the Alito residence. One was a flag flown up, an American flag flown upside down. That is, with the stars and stripes at the bottom, rather, or with the stars at the bottom rather than at the top. And the other was a flag apparently flown in his backyard sometime earlier, which is the so-called "Appeal to Heavens" flag. And Alito argues that no reasonable person could conclude that as a result of the flying of that flag or those flags at his home, he can't be fair and impartial. And he notes that his wife has a joint interest in the home, and that she likes flying flags, and that in her flag flying ways, she once flew a flag of the United States in distress after a bitter neighborhood confrontation with one of the neighbors who, according to Alito, followed the couple one day on the street using the vilest possible terms to refer to Alito's wife. And he notes, Alito does, the great sacrifice that his wife has made in living with him as a public figure whose neighborhood, whose home and address has been made known to the world, and whose home has become a source of public controversy. And he says, is it the case that she can't have opinions about what's going on in the neighborhood? Is it the case that she has to be silenced and muzzled to assure the appearance that Alito has no views that might trouble someone? And he says, of course, the answer is not. In the backyard case, apparently at some point, uh, not in the not too distant past, she flew the "Appeal to Heavens" flag. And I think Alito says he didn't know. I was not familiar, he writes, with the "Appeal to Heaven" flag when my wife flew it. I kind of doubt that. The "Appeal to Heaven" is a famous line from John Locke's second treatise, which basically talks about the people's retention of sovereignty, even when they have yielded it to government. They have the right, if they believe that government has behaved unjustly, to take it back, as it were, to take their sovereignty back. They don't go to the sovereign and say, "We don't like you, give it back." They take it back by force of arms, and that's the so-called "appeal to heaven." And you'll recall that Locke was writing in the wake of the English Civil Wars, writing contrary to that view of the source of sovereignty or public authority as flowing from kings and from God, the so-called divine right of kings. And his second treatise of government became the classic statement of popular sovereignty. That is, that power comes from the people, and the people can take it back if they believe government behaves unjustly. And thus, Locke writes late in the second treatise about the so-called "appeal to heaven." And that's where people decide to resort to arms to take their sovereignty back. And Locke writes with caution, be careful if you do this. Emerson once famously said, if you shoot a king, you best kill him. And the fact of the matter is that a people who revolts against its government does so at considerable risk. You either win, or if you lose, the sovereign exacts its vengeance on you. And so the "appeal to heaven" is not to be taken lightly. I noticed "appeal to heaven" flags flying in Connecticut early in the government's response to the pandemic. Some neighbors of ours began to fly them because they believed that government had overreached and had taken on more power than it had been given by the people. And they were apparently suggesting in that it was time for the people to take back power. I find that a easy rhetorical move to make, but a difficult life to live. And I can't help but wonder, as I watch the unfolding of politics in this first quarter of the 21st century, whether our rhetoric matches the lives we really care to lead. There are a lot of people out there that are talking incendiary, revolutionary talk, but yet there really is no revolution going on. There are heated political debates, and those debates sometimes spill over into acts of political violence, as many people engaged, as happened, frankly, on January 6th at the Capitol. The losers in that instance have been punished severely by the sovereign. I think that's a huge mistake. I think it's a national tragedy. We've gone from transforming January 6th from an afternoon's riot into a discrete subchapter in American history about which people will now debate for decades to come. I find myself drawn into that debate, given my ongoing representation of Joe Biggs and Zach Rell in the appeal of the Proud Boys conviction. I recently started to listen to a book called Sedition Hunters, about those who are seeking to track down those who participated in January 6th, to understand what would motivate people to engage that kind of effort in tracking down rioters to make sure they're punished. And what I noted was that there is a tremendous debate going on in the country, as Mike and I have noted from day one in this podcast, about the nature and source of public authority. And that we are experimenting as a culture and as a society with incendiary rhetoric. And so in the Alito case, his wife put up an appeal to heaven flag, which some people will take to be a direct call to action against the federal government, by making an appeal to heaven, by engaging in an act of revolt. And I think that Alito's response to the letter, I simply think he's disingenuous. I don't think he told the truth that he didn't know what the flag was. But I did say that, but I do believe that she had the right to fly it, as his wife. He may. I'd like to be a fly on the wall in the Alito household. He writes, as I said in reference to the other flag event, my wife is an independently minded private citizen. I would say so. She makes her own decisions, and I honor her right to do so. Um, is I mean, yes, yes, and I think that Durbin and company are wrong, to call for Alito's recusal on the basis of his engagement or his wife's engagement, with this symbolic speech. I can't help but wonder when we're going to stop arguing about such matters, and I hope the time comes soon.
Well, Norm, a while back you did a long form on court packing and the history of court packing. And if you
Mhm.
recall, I know our viewers recall when President Biden was on the virtual campaign trail. That was one of the promises of his campaign early on, was to launch an assault on the size, to expand the scope of the court, the size of the court, in an effort to install additional justices. This to me is relevant. I bring up Montour Wire's comment. I had it on the screen a few minutes ago. I brought it back up. This was from 3 years ago. Convenient timing, since there are important decisions pending. This court has been faced with a litany of what we would consider to be important decisions in this term. So I tend to agree with this, but it's not necessarily new. The Supreme Court, Clarence Thomas in particular, has been under scrutiny. The philosophically right leaning side of the court has been under tremendous scrutiny and under tremendous pressure, investigation, etc., since the beginning of Biden's term as president. So this coming from the senators that it comes from, Durbin and Whitehouse, is not altogether surprising. I think what's most surprising to me, Norm, is two things. One, that Alito published this letter. Um, and then number two, that he took the tack that he did. Because I read this with a great deal of humor, dry humor, albeit, but with a great deal of humor. So I kind of feel like he had a little bit of fun with this exercise, in particular when he says, my wife loves flying flags. I do not, kind of thing.
Yeah, I'm sure he did. But, I guess, uh, you know, and I know I'm going to like draw the ire of half of our listeners and viewers at this point, but, I still go to court every day. Um, well, every day that I go to court, which is most days, with a client standing to my right or left, depending on which table I'm standing at. And that client always has an interest that I have been retained or appointed to defend, and represent. And I represent that interest, under the rule of law. That is, it's a case or controversy of a particular type with a governing body of substantive law and in overlapping set of rules of evidence and procedural questions. And to me, that is a vocation. It is a calling. It's not a religious vocation, although it requires the sort of dedication that you would give to a religion because of the number of horrible things that you see and are required to make part of your own life in order to capably and loyally represent your client. And when I walk into a courtroom, having identified my client's legal interest, having identified a body of law, having identified legal theories that I intend to advance in the name of my client's interests, that's not a game to me. That is a form of intellectual and social, and you can even call it spiritual warfare. A lawyer's job is to be a zealous advocate on behalf of his or her client, and that zeal requires an investment of self. And I don't want the investment returned with something that minimizes what's at stake in the proceedings. And so I understand Alito thumbing his nose at Durbin and White House. But the better response, in my view, would have been to ignore it altogether.
Yeah, that's why I said I think it's interesting that he published the letter, right? That I
Yeah.
just I and maybe a sign of the times, right? Maybe the court is under tremendous pressure right now, and maybe this is reflective. I mean, we've gotten no answers to the leak around the Dobbs decision, right? The
Oh,
court
we have.
you know what I mean? The court is embattled in a way that I don't think historically we've really ever seen, or at least not with this frequency, and to this degree. Uh,
And
uh,
what's more, it's in a timely letter and a timely discussion
it
because
is,
next
it is.
month is June, and we're going to have the most significant cases of the term announced, which will produce God only knows what sorts of consequences in the public at large. These are very emotional times,
So I wanted
and
to
very.
bring this up because I saw I think Cernovich may have made a reference to this. And Dawn, I do apologize. I don't mean to steal your thunder if this was organic to you, but I did see this proposition online yesterday, and I want to ascribe it to Cernovich. I think this is something that he either pointed out that somebody else had said or he himself said. I can't remember, but I find there to be I like the essence of what this thought really is. Right? If Alito's wife is relevant, why is Mershon's daughter not relevant? Both irrelevant in my opinion. So great
Good point.
qualification there at the end. But I agree. Principally, we can't have one of each here, right? If we've got senators that are writing to demand recusal of a Supreme Court justice based on the independent acts of his spouse in flying flags, which this isn't even explicit speech, it's symbolic speech, right? Um, why is it that we are why if that is the standard state of play, why are we then not allowed to question the political affiliations and activity in commerce between the sitting judge in the most high profile criminal case in the country right now involving the most popular challenger to the presidential office in the country with tens of millions of people already in tow. Why are we not allowed? Why are we not allowed to at least question his ability to remain unbiased? And I'm not saying
Great
that we're not
question.
allowed to, but it does seem that these two questions get starkly different treatment by establishment media, Norm.
But not by me, because I've said in both cases I think they're
Oh,
irrelevant.
and Don says the same thing as well. Both irrelevant in my opinion. That's why I said great qualification, but I do think again the essence of that thought is, and sometimes it's boring to point out hypocrisy. I'm sorry, and I do apologize for doing that. I know it doesn't really advance the ball for us, but it does at least in the interest of trying to create some parity between um, the political sides. This is, I think, one of the most relevant considerations du jour.
Yeah. Well, it's certainly an interesting question, and it just, I just find myself doing a gut check this morning as I brace myself for June's release of opinions and the divisions that they will yield in the country. I long for a reasonable sense of the center and for a discussion among people of goodwill where we can respect reasonable differences about outcomes without politicizing and demonizing our adversaries to the degree that has become the norm, no pun intended, in American politics just now. But that's why we have law and legitimacy every day so that we can study our differences, we can discuss them, and hopefully promote a reasonable discussion among people possessed of reasonable minds, because I believe almost everybody has one. We didn't quite make it all the way through our topics today, and I guess that we'll leave Scottie Scheffer for tomorrow. The charges against him have been dropped. I don't recall ever studying video of his quote unquote confrontation with the cop.
Well, I'll make sure to have that queued tomorrow then. We'll play it, at least the video footage that we have, because recall the
Yeah.
officer, you know, what's interesting, just to prime everybody to this, I'm sure we all saw it. Maybe not you know, I love this because I think I kind of called my shot on this early on. But you know, the officer, the arresting officer, I think his last name is Gillis. He put out a statement as well, Norm, yesterday, and was laudatory of Scott and the way that he conducted himself, the way he spoke to him throughout the entire process. His criticism was of the defense attorney and the remarks that he made in the aftermath. So we'll play. There's I think there was about a 15-minute press conference with the defense attorney yesterday, but there's a 55-second clip from that full 15-minute press conference that's circulating. I'll make sure you've got that. We'll play also the video that we have from the, I think it was street camera footage or another surveillance camera in the area that shows at least some part of the quote unquote dragging of the arresting officer and Scottie, and we'll go from there. But I thought it was interesting. I think I sent it to you, Norm, saying that, you know, the prosecutor said that he couldn't, in good conscience or good faith, or, you know, in the interest of conducting his duty in upholding that duty of candor toward the tribunal, maintain the charges against Scottie yesterday. And so there's video and audio of that. I'll see if I can find all three of those things for us to analyze.
Great. Well, thanks for tuning in to Law and Legitimacy this morning, folks. We appreciate your continued interest. We'd ask you to spread the word. We don't think there's any reason in the world, in spite of Blue Raptors.
We'll talk about self-checkout too. I want to talk about self-checkout. I am a zealot against self-checkout, a prohibition.
Well, I don't even know what that is, but we'd like you to encourage you to spread the word that we're here and get people to follow and support us. We're committed to bringing reasonable minds, reasonable discussions about the topics that divide us each day. Thanks for listening. AMF Yo-Yo. How do people find us, Mike?
You can find us right here at Law Pod Daily from whichever platform you are coming to us from, whether that be X, YouTube, Law and Legitimacy on Rumble. You can also find our streams in audio-only format on Apple Podcasts, Spotify, Google Play, Overcast, wherever you find premium podcasts. Those episodes are uploaded immediately after the conclusion of each stream each day. Please make sure you are subscribed. Please ensure that you have liked this video. Jules, another shout out to you for the tip. Thank you, my good sir, for testing that out. Just to reiterate, super chats are now live here. We do appreciate you, Norm. I'm really liking the traction we're getting in these last few mornings. So let's keep having some fun. See you tomorrow.
Right. That's good. Ciao. Be well, everyone.
Bye.